In the intricate landscape of international relations, the term casus belli stands out as a critical concept. Rooted in Latin, meaning case for war, casus belli refers to the justifications or reasons a state might cite to legitimize the initiation of hostilities. Understanding casus belli is essential for comprehending the complexities of global conflicts and the legal and ethical frameworks governing warfare. Historical context of casus belli. Historically, casus belli has played a pivotal role in the outbreak of wars. From the Peloponnesian War in ancient Greece to the world wars of the 20th century, nations have invoked various reasons to justify their entry into conflict. For instance, the assassination of Archduke Franz Ferdinand in 1914 served as the casus belli for Austria-Hungary's declaration of war on Serbia, ultimately igniting World War I. Legal frameworks and casus belli. In modern international law, the concept of casus belli is closely linked to the United Nations Charter, particularly Article 51, which recognizes the inherent right of self-defense if an armed attack occurs. However, this right is subject to interpretation and debate. The legality of a casus belli often hinges on whether the reasons for war align with principles of necessity, proportionality, and immediacy. Common types of casus belli. 1. Self-defense. This is the most widely accepted casus belli under international law. A state may resort to war if it faces an imminent threat or actual armed attack. The 2003 invasion of Iraq was justified by the United States and its allies on grounds of preemptive self-defense against alleged weapons of mass destruction. 2. Humanitarian intervention. Sometimes states justify war to prevent gross human rights violations, such as genocide or ethnic cleansing. The NATO intervention in Kosovo in 1999 was framed as a humanitarian effort to stop the persecution of ethnic Albanians by Serbian forces. 3. Retaliation. Retaliatory actions can also serve as casus belli. These are often responses to previous attacks or breaches of treaties. The Israeli strikes against Hezbollah in Lebanon in 2006 were in retaliation for cross-border attacks and abductions. 4. Treaty obligations. Alliances and defense treaties can compel states to enter wars. For example, the complex web of alliances in place before World War I obligated various countries to support their allies, escalating a regional conflict into a global war. Ethical considerations of casus belli. Beyond legality, the ethical dimensions of casus belli are equally significant. The just war theory, dating back to philosophers like Augustine and Aquinas, provides a moral framework for evaluating the justifications for war. According to this theory, a war is just if it meets criteria such as a just cause, right intention, legitimate authority, and last resort. Modern debates on casus belli. In contemporary times, the concept of casus belli continues to evolve, especially with the advent of new forms of warfare, such as cyber attacks and drone strikes. The threshold for what constitutes an act of war is constantly being reassessed, making the international community's consensus on legitimate casus belli more crucial than ever.